Hello, everyone. I wanted to give it a couple minutes to let people are coming in now. In the meantime, I did post into the chat some helpful information. If you need to reach out to me, maybe you can't stay for the whole presentation or you want to reach out to me after the presentation, please feel free to email me. My email address is posted in the chat, hulse@mcandrewslaw.com. My phone number is also there, as well as our website address. And then I posted Abilities 21 Special Needs Support Group of NEPA is a wonderful you can find them on Facebook. They are sponsoring this presentation, and they provide a lot of really great information for families that have students with disabilities. Okay, I'm gonna go ahead and get started. Um, Good evening, everyone. My name is Heather Hulse. I am a special education attorney with McAndrews, uh, Mehalick, Connolly, Hulse and Ryan. We are a firm that practices in special education with disability law, special education, estate planning. We have a large practice in special education law and several offices across the state of Pennsylvania, as well as in Delaware and Washington, D.C. I'm doing this presentation in conjunction with the wonderful Abilities 21 Special Needs Support Group of NEPA. You can find them on Facebook, and they provide a lot of really helpful information for families that have students with disabilities. I also posted in the chat my contact information, so feel free to reach out to me via email or via telephone. We also have a website address I posted as well, that has a lot of really helpful information, tons of articles on various topics in special education. I will be taking questions as well, so feel free to post those questions in the chat, and I will get to those at the end. If for some reason you need to leave early and have a question, please let me know. So first, let's start. What are we talking about tonight? This is Special Education 101, the basics of special education law, and really what every parent and guardian should know. So what is the law that we're talking about primarily? It's called the Individuals with Disabilities Education Act, or the IDEA. And it provides for all the various evaluation process, the provision of IEP. Students with special education needs must be provided with what's called a free appropriate public education. We hear often FAPE. Was the student provided with FAPE? The school district or charter school may tell you that they believe they're providing your child FAPE. and that's pursuant to the Individuals with Disabilities Education Act. So what does FAPE mean? What is a free appropriate public education? It is a program, and that's going to happen through an IEP, through an individualized education program. And that program must be reasonably calculated to afford meaningful educational progress in all domains. So that would include academic, social, emotional, behavioral, physical, in areas of speech and language, in areas of occupational therapy, physical therapy, developmentally. So an IEP is designed to address the all areas of education. And oftentimes people think, well, education has mostly to do with academics. And education actually has to do with much more than just academics. So if a student is not making progress socially, if a student is not making progress emotionally, if the student is struggling in areas of speech and language, these are all part of special education, providing the student with a free, appropriate public education. There are eligibility categories under the IDEA, Individuals with Disabilities Education Act, for which a student may be found eligible. So there's two slides here that discuss the eligibility categories that a student may be found eligible. Autism, deaf-blindness, deafness, emotional disturbance, hearing impairment, intellectual disability, multiple disabilities, orthopedic impairment, and other health impairments. So there's going to be another slide, but I want to touch on just a couple of these. In terms of autism, one thing that I think is important to remember. So first off, before we get into specifically, sometimes school districts or charter schools will tell families that, oh, we can't provide an IEP unless you have a diagnosis from your medical doctor. Oh, you think your child has autism, you think your child has ADHD, attention deficit hyperactivity disorder, and needs an IEP. You need to go out and get a medical diagnosis from your doctor before we can do anything. That is inaccurate. And there's clear case law that school districts do not need a diagnosis. A parent does not need to go out and get a medical diagnosis or a psychological diagnosis. These eligibility categories on this slide and the next slide we're going to be talking about are actual legal categories under the federal law where a student would be found eligible. So where a student may be diagnosed with autism, they may or may not be found eligible as a student with autism under the IDEA. And a student doesn't need to have that diagnosis with autism to be found eligible under autism under the IDEA. Similarly with, and we're going to talk about other health impairment. So other health impairment is where your, as well as other disabilities would fall under, but other health impairment actually means having limited strength, vitality, or alertness, including a heightened alertness to environmental stimuli that results in limited alertness with respect to the educational environment. And that's where you're going to see your attention deficit hyperactivity disorder fall under that. It has to be due to chronic or acute health problems such as attention deficit hyperactivity disorder, asthma, diabetes, heart condition, epilepsy. So there are various other Tourette syndrome. There are various other disorders that may fall under that other health impairment, but we frequently see attention deficit hyperactivity disorder falling under that eligibility category. Another one I want to touch on just a little more specifically is emotional disturbance. And the reason is, number one, it's a common category for students to fall under because it's social, emotional, behavioral needs will fall under here, but also because it's quite broad. And oftentimes I'm not sure how if people are aware how broad this category is. So the definition of emotional disturbance is a condition exhibiting one or more of the following characteristics. So you don't need to meet all of these factors that I'm going to go through. You only need to meet one of them. You do need to meet it over a period of time, a long period of time, and to a marked degree that adversely impacts the child's educational performance. Remember that educational performance is not just academic performance, so social performance, emotional performance, so behavioral performance. So if a student is exhibiting an inability to learn that cannot be, emotional disturbance is an inability to, again, any one of these factors. An inability to learn that cannot be explained by intellectual, sensory, or health factors. An inability to build or maintain satisfactory interpersonal relationships with peers and teachers. Inappropriate types of behaviors or feelings under normal circumstances. Or a tendency to develop physical symptoms or fears associated with personal or school problems. And finally, a general pervasive mood of unhappiness or depression. So again, you don't need to, the student would not need to meet all of those factors, one of those factors. So if they're demonstrating inappropriate types of behaviors or feelings over a period of time to a significant degree, and it's adversely impacting their educational performance. Again, remembering that could be social performance, emotional performance, or behavioral performance. They would be eligible under the category of emotional disturbance. These are additional eligibility categories that students may be found eligible under: specific learning disability, speech and language impairment, traumatic brain injury, visual impairment, and developmental delay. So I want to talk a little bit about specific learning disability. Again, another common disability category. And this means a disorder in one or more of the basic psychological processes involved in understanding or in using language, spoken or written, that may manifest itself in the imperfect ability to listen, think, speak, read, write, spell, or do math. And these so students can be found eligible for specific learning disabilities in areas of reading, written expression, mathematics, listening comprehension, oral expression, and we're going to talk a little bit more about how that is determined as we move on. And then finally, in terms of speech and language impairment, because I think this one is often overlooked. Oftentimes you will see speech. Speech is frequently identified and addressed by school district in terms of if a student has those articulation needs, so struggling with maybe R's and L's, TH's. But oftentimes we see those students that have a more not necessarily an articulation need, but other areas of language, language processing, expressive language, receptive language, pragmatic language, which is social language. So those are also areas of speech and language impairment that need to be addressed by school districts. And I want to make sure that that is not overlooked. So in terms of a free appropriate public education, one thing that needs to be generally considered and adhered to is students must be placed in what's called a least restrictive environment, or LRE, consistent with their needs. And I'm going to talk a lot about what that means. But essentially, special education students must be educated with their typically developing peers to the maximum extent appropriate. So that means we would start with the regular education environment and work our way out. But again, it's to the extent appropriate. So this sort of goes both ways. Oftentimes you will see school districts moving too quickly through that process, so moving from a regular education environment and going straight into a out of district partial hospitalization, very restrictive. And what we mean by restrictive is not with typically developing peers. So if students are placed into a partial hospitalization program, say for social, emotional, behavioral needs, all of those students in that program have special education needs, or theoretically they have special education needs. So you are taking that student out of their least restrictive environment, which would be regular education, and even beyond that. So you'd have regular education and working your way out. Maybe the student spends some time in emotional support, or some time in autistic support, some time receiving speech and language services, occupational therapy services, social work services, counseling services. These are all services that are considered special education and taking the student out of that regular education environment. But moving to a highly restrictive, out of district placement, a school that's for students with social, emotional, behavioral needs, or an autistic support school, that would be considered a more restrictive placement. And again, we want to work our way. The law says we want to start with that least restrictive environment and provide the full range of supports and services within that environment before we would move into a less restrictive, or excuse me, more restrictive environment. However, I also want to talk about how sometimes that can go the other way. Sometimes I've had school districts, a couple school districts in particular, that consider themselves what they call a fully inclusive school district, which essentially means all students are in regular education environments and they get support from the learning support or emotional support teacher, maybe in a resource room where they're pulled out for a period of time, but they're not receiving their educational instruction in terms of reading, writing, math. That all happens in the regular education environment. So that can be problematic because let's say you have a student that has a learning disability in reading. And I'm going to take dyslexia as an example. So students with dyslexia would fall under the specific learning disability category of certainly basic reading skills and oftentimes reading fluency and maybe even reading comprehension as well. So the categories for specific learning disability in reading under the IDA are basic reading skills, reading fluency or oral reading fluency, and reading comprehension. So a student may be eligible under one, two, or all three of those areas of reading. And like I said, a student with dyslexia would most certainly qualify under basic reading skills and may also qualify under the other two. But when a student with dyslexia will struggle with phonological processing, phonemic awareness, blending of those basic sounds, so decoding letters and sounds. So those are your basic reading skills. So if you have a student that has, let's say, severe dyslexia, and let's say they are in third grade, well, no, let's say they're in fifth grade and they're functioning on a second grade reading level. So to put them, if we're in a fully inclusive school district, as they say, and you put them in regular education and do not give them a learning support environment for them to learn, to receive that research-based instruction that they need to address their specific needs, that's going to be problematic. So again, that least restrictive environment needs to be considered, whether the student has significant needs or does not have significant needs, but we want that student in the least restrictive environment, and again, to the maximum extent appropriate. So just a couple more points on that topic. Special classes, separate schooling, other removal of special education students from that regular education environment should only occur if the nature and severity of the disability is such that the education in the regular education classes with the full range of the supplementary aids and services cannot be achieved satisfactorily. So again, we start with that regular education environment and the full range of services. So if that student's needs can be met by providing more push-in services or having even pull-out social work services, but those happen weekly and that student can stay in that regular school building in that regular instruction, then that's what we need to do. If the student's needs can be met with a one-on-one aid in that regular education environment, that's what we should be doing. That's what the law says. So again, there's there's a Third Circuit Court of Appeals decision. It's sort of a landmark case called Alberti versus Board of Education that describes decided that this least restrictive environment must be adhered to. So school districts must consider the full range of supplementary aids and services that can be provided in the regular education setting, and the school district and charter schools must make efforts to modify the regular education program to accommodate a special education student. So they cannot just say, oh, we can't do that. We can't do that in regular education. They have to make those efforts to modify. And the ID also specifically provides that special education students should not be removed from education in age-appropriate regular classrooms solely because those modifications are needed in the general education classroom. So again, it's not, well, this is what our general education classroom is. We're going to need to move your child out of it because we can't modify those needs. Accommodations and supports must be provided as necessary to make meaningful educational progress to allow maximum integration with non-disabled peers to participate in extracurricular and non-academic activities as well. So this provision of least restrictive environment also also has to do with extracurricular activities and non-academic activities, but we also need to make accommodations and supports so that students can participate. So if a student wants to participate in an extracurricular activity or an after-school activity that's part of the school district, they should be provided with accommodations necessary so they can do that and participate with their non-disabled peers. Similarly, with regard to field trips, because I do sometimes hear parents will tell me, oh, they told me my child can't go on the field trip because their needs are too significant. That is not appropriate. That is not something that's provided by law. They are legally obligated to provide whatever accommodations and supports and services are necessary so that your child can attend regular education field trips. So we're going to talk a little bit about child find, and that is the initial identification of students with special education needs. So how do we identify a student with special education needs? A parent can request an evaluation. A parent can come to the school district and say, I believe my child has needs, academic needs, social, emotional, behavioral needs, speech and language needs, whatever it may be that they believe their child has, and they can request that evaluation. However, it is the school district's obligation to ensure that students with disabilities are properly evaluated and identified. So child find means that the state must have in effect policies and procedures to ensure that all children with disabilities residing in the state, including children with disabilities who are homeless, including children with disabilities attending private schools, and regardless of the severity of their disability, if they are in need of special education and related services, that they are identified, located, and evaluated. So this means that children who are suspected of being a child with a disability. So we don't have to know that child has a disability. Again, we don't need a medical diagnosis. We have to suspect that that child has a disability in any area of special education need. And this it doesn't matter if they're advancing from grade to grade. The child doesn't have to fail to be eligible for special education services. So a school district's obligation, if they suspect that a child is a child with a disability, they must offer to evaluate. And this would also include highly mobile or migrant children. I'm going to talk a little bit about those evaluations. Before I do, though, when a parent requests an evaluation from a school district or a charter school, they should do so in writing. Always best to do things in writing, and that way you have verification. You can go back and follow up. Email is wonderful because you can just go ahead and forward your email if you didn't get a response and say, hey, I'm following up on the request below, and there's documentation. If you make that request verbally, there is a chance that the school district or charter school will say, we didn't receive a request for an evaluation from the parents. So always best to put it in writing. Indicate why you're requesting the special education evaluation, so that your child can be evaluated in all areas of suspected need. So if your child's struggling academically, social, emotionally, behaviorally, in areas of communication and occupational therapy and handwriting, with executive functioning, the ability to plan and organize, put in whatever areas that you believe your child's struggling in, so that the district is on notice that they should be completing all these types of assessments. So when a parent does that and they put in a request in writing, the district has a legal obligation now to respond. And they can either agree and say, yes, we agree to evaluate. They will issue what's called a permission to evaluate, or sometimes a prior written notice, consent for an evaluation. They might issue both of those. They might issue what's called a notice of recommended educational placement for the evaluation. Various school districts do various things, but essentially they're going to get your consent to evaluate. Once you get that document, you want to consent and send that back to the district right away, because the district's timeline for evaluating does not begin until they receive back that evaluation that has been indicated, that consent has been indicated. So once you get that, you check the box that you consent, sign, date it, return it to the district. Again, if possible, always better to return it to the district via email so that you have record that you've returned it. If that's not possible, you can always I would go in person, go into the administration building and get them to give you a time-stamped copy that they received it. So then you have a hard copy that you've received, that they have received that consent form. Because once they receive that consent form, they have 60 days, excluding summers, and we'll talk a little bit about that, but 60 days to complete that evaluation. So summers don't count. It's calendar days, so it's not business days or weekdays. It's 60 days, but the summer, from when the school is out of session till the school is back in session in the fall, will not count as part of that time frame. However, there is law that provides right in the IDA that a student should be provided with an appropriate IEP from the start of the school year. So if you are making a request for special education evaluation and you know that 60 days is going to run into the summer months, and maybe it's only a few days, so you want to note that in your request, that, or even on the permission to evaluate. I understand that the district has 60 days to evaluate. Summer is excluded. Summer months are excluded. However, I believe my child needs an IEP before the start of the school year, and I'm therefore requesting that the district complete the evaluation before the start of next school year. Their school psychologists do work over the summer, so it is possible, and maybe even if they know that you're really looking to have that evaluation completed, they can get it done before the school year ends, to get that completed. So, and then in terms of if they do not agree to evaluate your child, they would have to issue what's called a Notice of Recommended Educational Placement, NOREP, denying. So they would issue a NOREP saying, and sometimes they don't. So if they don't, feel free to give myself or someone like me a call. But if they are supposed to issue a NOREP denying that request for an evaluation and explaining why they're denying that request. At that point, then you can file for due process against them for that evaluation. I will say that if you do that and they have to go to due process for it, that can sometimes prompt them to say, okay, because it's actually more costly for them to go to a hearing than it is to evaluate. But you might want to also seek counsel just to someone like myself, just to see if there's a good reason why the district's denying that request. But I will say this, it's not common for school districts or charter schools to deny a request for a special education evaluation. In terms of evaluating, what does the scope of that evaluation or reevaluation need to look like? It must be sufficiently comprehensive to identify all of the students' special education and related services needs, whether or not they're commonly linked to the disability category in which the child has been classified or is sought to be classified. So let me explain that. So let's say that you're requesting an evaluation because you believe that your child has reading needs, and you make that request. And so they're evaluating for determination of whether your child has potential reading needs, potentially a specific learning disability. When that school psychologist is completing the evaluation, during the assessments, maybe they're doing a cognitive assessment, which is assessing the child's intellectual abilities. And there are various indexes that are assessed. And they also would assess academic achievement. And there's various areas of academic achievement that they would assess. So let's say when they're doing those assessments that there's some indications that your child may also have some language needs, or maybe when they're talking to them, they're picking up on those language needs. That the school psychologist should then make a referral for a speech and language evaluation and get your consent to do that as well. So all areas of need should be assessed. The initial evaluation is required when there is reason to suspect the child has a disability. So it's a pretty low bar. And then parents have a right to obtain an independent educational evaluation, often at public expense. So if the school district completes or charter school completes an evaluation and that you believe that evaluation either did not sufficiently evaluate all of your child's needs, did not find your child eligible, and you believe that the child should be eligible for special education, you can request what's called an independent educational evaluation. And you want to make sure that, first of all, I have to say, if you're at this point where you need to request an independent educational evaluation, it's probably a good idea to seek out someone like myself or a special education attorney. It has more teeth when that request for an independent educational evaluation comes from a special education attorney, because if the district were to deny it, so the district has two ways in which they can respond to a request for an independent educational evaluation. They can either agree to the parent's request or they can deny it. And if they deny it, they will file for due process against the parent. And that's why I say, if you're at that point where you're asking for an independent evaluation, or at least where the district has filed a due process complaint against you, it's a good time to have an attorney represent you. Proceeding to a due process hearing if you look at the outcome of due process hearings, there is a significantly higher rate of success for parents when they are represented by special education counsel versus when they are representing themselves. And it's not surprising because it's not only are you it's a complex area of law, and you have to really know what you need to prove, but also as a parent or guardian, you're emotionally connected to the child, and that can make it much more challenging to proceed through a due process hearing than if you're represented with a special education counsel who can see things clearly and can focus on what they need to prove in order to obtain the result that you're looking for. So back to that request for an independent educational evaluation. When you make that request for an independent educational evaluation, so when I make them, I always make sure that I include all areas that needs to be evaluated. So let's say the school district did a psychoeducational evaluation and should have also done a speech and language evaluation, an occupational therapy evaluation. The parent had requested needs in those areas, or maybe they did those evaluations, but they weren't sufficient. They didn't find the student eligible. You need to make sure that you're requesting an independent educational evaluation to include a psychoeducational evaluation or a neuropsychological evaluation and a speech and language evaluation, occupational therapy evaluation, a physical therapy evaluation, a functional behavior assessment. We're going to talk about those in a little bit too and what they look like. So again, assistive technology evaluation, auditory processing evaluation. So again, whatever the areas of need are that the district failed to sufficiently assess, you want to make sure you request that. And then again, if the school district can either agree, then you would have the choice of choosing those evaluators. Sometimes they will want to work to come to an agreement on mutually agreeable evaluators. However, if they are agreeing to a request for an independent educational evaluation, they are agreeing to allow you to choose that independent evaluator. They may provide you with a list of evaluators, but they should make it clear. And even if they don't, you should know that you are not glued to that list. You are, you as a parent, if they agree to an independent educational evaluation, you are able to obtain an evaluator of your choice. You should, of course, make sure that whoever you choose is highly qualified in the area that they're assessing. And also, we always make sure that they are willing to, if we need them to testify, that they be willing to testify at a due process hearing. There's some evaluators that aren't willing to do that. And if you need that, you want that at least available. Certified school psychologist needs to do a psychoeducational evaluation. So if you're seeking an independent evaluation, you don't want to go with a psychologist. Licensed psychologists are wonderful. They're wonderful humans and they do great work. But in terms of completing a psychoeducational evaluation for educational purposes, it needs to be a certified school psychologist. So just a couple notes on that. So now I'm going to get into an IEP, and that's really the heart of everything. So what is it that students are provided with when they are identified with special education needs? They have to be provided with an appropriate individualized education program, or IEP. And what is that? It's a written statement for each child with a disability. It's developed, reviewed, and revised in meetings with parents, guardians, and relevant professionals. So I'm going to take us through each of the components of an IEP and what that should look like. So towards the beginning of the IEP, there should be a statement of the child's present levels of academic achievement and functional performance. So this should be extensive. This should give you information about where your child's functioning in all areas of academics, major areas: reading, writing, and math. And specifically, it shouldn't say something like, Joey is reading below grade level, period. That's fine to say that, but then we need to get in specifics. Where are the areas of need that Joey has in reading? Because again, reading has many different components to it. So is Joey struggling in letter word identification, decoding? Is Joey struggling in fluency, being able to read quickly enough, correct words per minute? Is Joey struggling in reading comprehension? Is vocabulary an issue? So again, it's important to give more specific information than just below grade level. Similarly with math, where are the areas of need where the child is struggling? In areas of written expression, struggling in essay composition, punctuation, grammar, spelling, all of the above. So we should have all that information. And in terms of functional performance, this again should be an extensive area that covers all your child's areas of need. So socially, emotionally, and again, it should not just be one sentence about, child has social skills below his peers, or so. We should have detailed information about the specific social skills needs, the specific social skills deficits. Is the child struggling with engaging with their peers to begin with? Are they withdrawn, or are they struggling with giving up control? Are they struggling with being able to take turns? Are they struggling with, again, there's many areas of social skills deficits. We need specific information about where your child is struggling. Emotionally, same thing. Anxiety, is it emotional regulation? Is it not having insight into their emotional needs? What specifically are the areas of deficit? Executive functioning, those which is essentially your ability to plan and organize and transition from task to task. There's various areas of executive functioning where a child can struggle: distractibility, initiating a task, following through with the task, transitioning from task to task, organizing tasks. Where is that child struggling in those areas of executive functioning? Behavioral performance, same thing. Where are the behavioral needs? And we're going to talk a little bit more about behavior, but behavior is real important to understand the function of the behavior. So there needs to be a whole assessment on when those behaviors are occurring, how frequently they're occurring, in what circumstances they're occurring, in structured versus unstructured. Is it certain classrooms? Is it with certain peers? Is it with certain teachers, certain adults? Are there environmental factors playing a part? Are there sensory needs at issue? Are there language skills factoring in? So those are all really important in that. The present levels of education should give you a very good understanding of all of the areas of need as well as the strengths of your child. And because this is the information that is used to develop the goals and the specially designed instruction that are going to come into the next components of the IEPs. So the next component of the IEP is a statement of measurable annual goals, including academic and functional goals. So there's a section where you'll have goals in the IEP. Those goals must be measurable, meaning that we need to be able to progress monitor. We need to be able to tell if the student's making progress. So they need to be specific, and we need to have an understanding of how that progress is being measured. So the method that's used for measuring progress. So you wouldn't have a goal like, for example, Mary will improve in reading. I mean, that's a silly goal. Every student should be improving in reading. So you wouldn't have something like that. It's got to be a very specific goal. So for example, let's say fluency is an issue. And let's say we need a baseline. So what's Mary's baseline right now? How many correct words per minute is she reading? And then at what grade level is that at? And then where do we want to get her by the end of the year? Because IEPs are annual, so we need annual goals. So we want that goal to be, we want her to make meaningful progress consistent with her ability to do so. And remember that a specific learning disability does not mean you don't have the ability to make progress consistent with your same age peers. An intellectual disability could impact your ability to make progress consistent with your same age peers, but not a specific learning disability. So the students with specific learning disabilities can learn consistent with their same age peers. They just learn differently. So we need appropriate research-based programs that target their specific areas of need. So for example, a student that has those decoding phonological processing needs will need a program that addresses those decoding phonological processing needs. A student that has reading comprehension needs will need a program to address those reading comprehension needs. And don't be afraid to ask your school districts, what research-based program are you using? Are you using a research-based program? And when they tell you what they are, go home and Google them. And learn about those programs and what they're doing and what they're addressing, and make sure they're actually addressing the areas of need. So, and then in terms of goals, not only do they need to be measurable, they need to address all the areas of need. So if your child has academic needs, those need to be addressed in the goals. If they have speech and language needs, we need speech and language goals. If they have behavioral needs, we need behavioral goals. If they have emotional needs, we need goals for coping skills. If they have executive functioning needs, they need goals for executive functioning. Those goals will also include a description of how that child's progress will be measured toward meeting. So again, the method for measuring progress. How are we going to measure the goal? So are we using a curriculum-based assessment? Are we using a component of a research-based program, for example? Are we using data collection? So that should specifically tell us what we're using to measure progress. And if you don't understand, don't be afraid to ask the schools, what does this mean? How are you measuring progress? So that you understand what those progress monitoring, which you should be getting quarterly, progress monitoring reports mean. Periodic reports, when will they be provided? Typically it's quarterly. However, progress monitoring reporting can happen more frequently if that's what's appropriate. And that can often be the case, especially when we're talking about a student that has more significant behavioral needs. We don't want to wait till the end of a quarter to report the progress. If there's significant needs, we want to be tapping into that much sooner so that we can, hey, if there's something we need to do differently, okay, great, we're doing things great, the child's making progress. So we can ask for more frequent progress monitoring reports to be provided. Another IEP component is a statement of special education and related services, supplementary aids and services based on peer-reviewed research to the extent practicable, and a statement of the program modifications and supports for personnel. So the first part of that is what is the student going to be receiving in terms of that special education, those related services, and again, it should be based on peer-reviewed research. And what we mean by that is research-based instruction. So it's instruction that has been proven to be effective. There's been studies that have been completed, and we know that this program works with students that have these types of needs. So there are research-based programs for all areas of need. Academics, reading, writing, and math, there's research-based programs, tons of them. if your child has social skills needs, there are research-based programs for social skills needs. And I'm talking all kinds of needs. And it's going to depend. You might have social skills needs at the elementary level, at the middle school level, at the high school level, and all different needs within those. There are research-based programs for executive functioning. There are research-based programs for behavior. There's research-based programs for emotion, coping skills. Zones of regulation, for example, will teach students how to identify areas of emotion and then learn how to regulate those emotions. So in that IEP, it should include a statement of how, when that student's going to be receiving regular education versus special education and what exactly they're receiving. It should also include a statement of program modifications and supports for school personnel. So there's a section within the IEP that says, what supports do the school personnel need in order to be able to support my child with their special education needs? So for example, you will often see in that section, let's say your child's receiving speech and language services or occupational therapy services. You might have in that section, it'll say consultation with the speech and language provider and the teacher will happen monthly. So that's a support for school personnel. What I also like to see in there is if you have a child that has a need that maybe the school personnel need some more understanding on. So for example, let's say your child has Tourette syndrome or Asperger's disorder. You can ask for, as a support for school personnel, that there be a training seminar on Tourette syndrome or Asperger's disorder or bipolar disorder, whatever it may be, so that that supports for school personnel, that school personnel is supported to be able to actually program for your child appropriately. An explanation of the extent, if any, to which the student will not participate with non-disabled peers in the regular education class or in other school activities. So they're in the IEP, and this is towards the end, it will explain that your child's in regular education for these classes and they're going to be in special education for these classes. So at what point, or maybe they're pulled out for services and they're not going to be participating with their non-disabled peers during that time. IEP will also include a statement of individual appropriate accommodations that are necessary to measure the academic achievement and functional performance of the child on state and district-wide assessments. So there's a section in the IEP that if your child's going to be taking the PSSAs, for example, the Pennsylvania System State Assessment, they will and needs accommodations for that. Now, there's only so many accommodations that a student can receive. We can't some of the accommodations or special design instruction that you'll see in an IEP, that child's not going to be able to get for their state assessments. The purpose of the state assessments is so that we can ensure that school districts are providing the proper instruction to students, a proper education, and that students are meeting those standards, those benchmark standards. So we're really assessing what the school district's doing with those PSSAs. So we don't, while your child is entitled to some accommodations, they're not going to be entitled to all the accommodations that they would get pursuant to their IEP. So the things that you may see for PSSA accommodation may be testing in a distraction-free environment. So maybe they're tested in their own room or with less students. They can get extra time up to a certain extent. They can get directions read to them. So there's some accommodations that can be included for PSSA testing. Now, on the other side, we have what are some supplementary aids and accommodations, specially designed instruction that can be provided for your child in their pursuant to their IEP. So real quick, I just want to talk about what's the difference between specially designed instruction and accommodations. And I may be jumping ahead because I think I have a slide on 504 plans, but so students with an IEP are, the reason they have an IEP is because they meet those one or more of those eligibility categories we talked about in the beginning. So they meet one or more of those eligibility categories, and they need specially designed instruction. So they need some type of instruction that is different or more specially designed to their needs than what a typically developing student would receive. So for example, if they have a need in reading and they have that phonemic awareness disability and basic reading skills, they're going to need that specially designed, that research-based program that will address that area of need that your typical regular education student will not need in order to make progress in reading. Similarly, in terms of if we're talking about other areas of need, so let's talk about executive functioning, for example. If your child, let's say, has ADHD, attention deficit hyperactivity disorder, they will have executive functioning needs. So it's a characteristic of ADHD, a major characteristic. So they will struggle with the ability to plan, organize, transition from task to task. To an extent. So we need to be teaching them. While we can accommodate those needs, we also want to be teaching them those executive functioning needs, because just because you have attention deficit hyperactivity disorder and you have those executive functioning needs does not mean you cannot get better and learn executive functioning needs. You can be taught them, and you can increase your executive functioning skills. There's executive functioning coaching that will help to increase a person's executive functioning skills. So that's a specially designed instruction that a student would need in order to increase those executive functioning skills. And as opposed to an accommodation. So let's take that example of attention deficit hyperactivity disorder. A student with a ADHD could receive accommodations such as extra time to do assignments, maybe reduction of assignments, being provided class notes so they don't have to take notes and while they're trying to listen. So those would be considered accommodations, whereas the actual direct instruction in teaching that student those executive functioning skills. So sitting down with them and teaching them, okay, how are we going to organize our materials? Are we going to color code our notebooks and our folders? We're going to put this in here. That's teaching them a skill, how to be organized, and that would be a specially designed instruction. Same with social skills. I have some of these listed on here. So specially designed instruction would include direct instruction in a group setting using multisensory research-based program. We have the direct instruction, executive functioning, social skills using research-based program, direct instruction in those social skills, direct instruction and coping skills. So actually teaching students coping skills that they can use, social skills that they can use. That would all be considered specially designed instruction. A one-on-one aid, more of an accommodation. Scheduled and unscheduled breaks, that's an accommodation. Access to a guidance counselor, that's an accommodation. Extra time for tests and homework assignments, those are all accommodations. So IEPs can have both specially designed instruction and accommodations, but what makes an IEP an IEP is that it will have, or it should have, specially designed instruction. Whereas a Section 504 plan, which is under a different law, it's called Section 504 of the Rehabilitation Act, and that is where a student has a disability that impedes a basic learning, would be what it would impede in our example. So if a Section 504 plan, if a student needs a Section 504 plan because they have a disability that impedes their learning, but they just need accommodations, they don't actually need that specially designed instruction. So then they would be eligible for a 504 plan. So here are some more IEP components under specially designed instruction or accommodations. Again, having the teacher's notes, study guides, providing choices, consistently catching good behaviors, a positive behavior support plan. We're going to talk a little bit more about that. Related services is another section of the IEP, and that is a pretty important one. That is, what are the services, the related services that a student needs? And it should tell you the frequency and the duration of those services, the type of services, whether they're going to be group or individualized. And what I mean by frequency is duration. Is it going to be twice a week for 30 minutes each, or, you know, 3 times a week for 45 minutes? So there's a variety of how that service can be implemented. So these are, and the next slide, are various related services that are all under the IDEA. So take a look at these, because I think sometimes people forget again how broad the Individuals with Disabilities Education Act is. We often remember those services like occupational therapy services and speech and language services, which I think is on the next slide, but diagnostic medical services, that's under the IDA. So that if that's something that the student needs, because we think that there's an impact on the child's education, that's something that the school district should be doing. Counseling services. I often get pushback. Well, we can set the child up with counseling services through the mental health agency, but we don't provide counseling services. This is under the IDA. It's a legal requirement under the Individuals with Disabilities Education Act. They are obligated to provide those counseling services, and those counseling services need to go in the IEP, and they need to have goals and progress monitoring. Parent counseling and training. So if you struggle to understand what your child's complete educational needs, that's a service that the district can provide, so you can get that proper training, so that you can help with your child's education and do the things that can be helpful to do at home. Physical therapy, social skills, audiology, interpreting services. These are more related services. Psychological services fall under the IDEA. Social work services, school health, school nurse services, speech and language, transportation. Transition services. So from when a student turns 14 years old, and they have an IEP, we need to start thinking about transitioning that child into, and that's it's going to change. At 14, we might not have everything in place. It'll develop over the next several years, but we need to be thinking about post-secondary education or post-secondary activities. So what is that child going to do when they complete their high school? And that may be, so it's a good time to tell you that a student with special education services is entitled to services, special education services and support, until the year that when they graduate from high school. That would end the school district's obligation to provide special education services and supports. But a student with special education may get services beyond those typical 4 years of high school, and can get services up to the end of the up to the end of the school year, where right now, when they turn 22, that may change. There's that's been challenged, so it may go back to the end of the school year where they turn 21. So they're at least entitled to services up to the end of the school year where they turn 21, but may even be till 22. And those services, I think it's important for people to realize a couple things. One, your child can still walk through graduation with their class, with their graduating class. They can get the cap and gown. They will get, no one gets an actual diploma on stage. You get that, you pick that up somewhere else. So they just don't get an actual diploma. They would bank their diploma, but they can go ahead and walk through graduation. Two, another thing to remember is it does not necessarily mean that they have to continue in the same building, in the same high school program that they were in. Maybe that's appropriate, but maybe it's not appropriate. Maybe the student needs some other type of program or service. Maybe they're going to get services in a vocational setting. Maybe they're going to get services in a another school program that's addressing more transitional needs. So it doesn't have to be, okay, the student's going to stay in the high school building for years and years and years. So I just want to make sure parents understand that. But again, that starting those transition plan programming, that should start at the age of 14. It should be based on appropriate transition assessments that are specifically designed to improve the child's academic and functional achievement, and must be designed to facilitate the child's movement into post-school activities. So, just want to make sure I didn't miss anything. So positive behavior support, I want to touch on a little bit. It's sort of a separate component, but it's all part of the IEP. If a student has behavioral needs, and there's a section in the IEP that's called special considerations, and one of those questions will be, has to do with whether the child's behaviors are impeding the learning of theirs or others. And if so, that box gets checked, and that means that the child should, we should have a positive behavior support plan that is developed. So the positive behavior support plan, first of all, it has to be based on a comprehensive functional behavior assessment, an FBA. So that's a whole nother assessment that would be completed by a school psychologist in conjunction with getting information from parents and the staff that work with the student. So usually what they do is they'll do what's called an FBA inquiry. So we start to talk about, okay, what do we think the student's behavioral needs are? What are their strengths? Where are we seeing those problems? Where are the teachers seeing those problems? Are they seeing them in structured environments versus unstructured? Are there particular classroom settings that they're happening in with particular peers? Parents should give input to what they see. And then the school psychologist should be observing that student, not just once. They should be observing them in, over the course of several days or weeks, different days, different parts of the day, mornings or afternoons, different types of settings. And again, basing that on some of the information that they get from that inquiry. So that functional behavior assessment, we can then determine what are the function of the student's behaviors. And it will also factor in areas of need. So again, if they have sensory deficits, if they have study skills deficits, they have language deficits, if they have academic deficits, and how that factors into their behaviors as well. So when we develop that we develop that positive behavior support plan, it's going to be based on information from that functional behavior assessment. The positive behavioral support plan should include research-based programming. So the student is being taught appropriate behavior skills. So again, that specially designed instruction is coming into play, and we're utilizing research-based programs that have been proven to be effective. Positive behavior support, hence the word positive, should be based on positive reinforcement. We should be reinforcing good behaviors or appropriate behaviors. There may be consequences for negative behaviors, but this should not be a punitive. We shouldn't be punishing the student for manifestations of their disabilities. And we're going to talk a little bit more about that. Interventions should be least intrusive. Restraints. So if your child needs to be restrained, first of all, that should only happen where there's a clear and present danger. And this is all this information here is law. This is not interpretation of law. These are actual, the language from the law. It's Pennsylvania law. Restraints where there is a clear and present danger only. That is, so a child should not be restrained just to manage behaviors. It should only be if they are a clear and present danger to themselves or others. There has to be written notice of restraint provided to the family within a reasonable time frame. Really, you should be getting that within 24 hours. An IEP meeting within 10 days of a restraint. So there has to be an IEP meeting. It has to be at least offered. If a parent wants to decline participating in an IEP meeting, maybe their child is restrained on a more frequent basis, and they'd be having IEP meetings all the time, so they can decline that. However, a school district must offer, every time that child is restrained, they must offer to hold an IEP meeting within 10 days. Restraints must be used in conjunction with teaching socially acceptable alternative skills. Again, this is in the law, those actual words. So you should, if your child is being restrained and you don't see anything in that IEP where we're actually teaching socially acceptable skill or socially acceptable alternative skills, there's a problem. That needs to be happening. The law doesn't want school districts and charter schools to just be restraining just to manage behaviors. We want to be working to eliminate the use of those restraints. Anytime a child is restrained, it needs to be by trained staff. So it should not be by anyone who does not have the proper training to do so. A plan to eliminate the use of restraints through positive behavior support. Again, this is clearly right in the law. There has to be a plan to eliminate the use of restraints through positive behavior support. So if your child is being restrained, you should ask the district, where's the plan to eliminate the use of restraints? How are we using positive behavior support to do that? I hope I don't have to say this anymore, but I keep it on there. No prone restraints. That's a face down restraint. That is illegal. No punishment for manifestation of disability. Again, this is right in the law. If your child's disability causes them to be impulsive, causes them to have trouble regulating their emotions, and they don't have the proper coping skills, we shouldn't be punishing them for that. That doesn't mean they don't need to make amends. Okay, I say that because I think it's important for, again, it's a teaching. We should be teaching the students, and in an appropriate way. How do you think your friend felt when you said, what you said, if they said something inappropriate, for example? So we don't need to necessarily punish them, but we need to hold them accountable in that we're processing them with that, and we need to help them formulate those positive decisions to make amends, to appropriately apologize for behaviors, to process that. So again, it's a teaching them those skills that they need. No locked room or room where exit is prevented. So students that are having, emotional behavioral meltdowns, we cannot just put them into a room. We cannot say, okay, put them in the sensory room and close the door or block the exit. You can utilize safe rooms and sensory rooms, but you can't lock a student in there or even stand in the doorway and prevent them from exiting. That's illegal. Suspension for more than 10 consecutive school days or 15 cumulative school days is considered a change of placement. So, and they cannot do that without your approval, except under certain circumstances. And we're going to talk about that in a second. But so a student cannot be suspended more than 10 days. A special education student cannot be suspended more than 10 days in a row. If there's 15 days in a row or 11 days in a row, then that's considered a change of placement, and you can't do that without the parent's consent. Or 15 cumulative school days, so 15 total days throughout the school year. If they go to day 16, that's considered a change of placement. Now there are exceptions. So and I don't think I have, I'm sorry. So the exceptions are if a student brings drugs or drug paraphernalia to school, or if a student brings a weapon to school, or if a student engages if they commit serious bodily injury against another student. So if they do one of those three things, then a school district or charter school may unilaterally, so you don't need parents' consent, And again, we're talking about special education students. So if a special education student brings drugs or drug paraphernalia to school, brings a weapon to school, or commits serious bodily injury against another person, then a school district can unilaterally remove them for 45 days. They have to put them into an alternative educational program, and that may be a variety of things. It might be a placement, it might be instruction in the home, it might be um uh they might have their own alternative educational program within their school district. So they can remove your child from their educational placement for 45 days. During that time, they must still provide your child with a free appropriate public education. So they still have to implement the entire IEP. Your child still is entitled to all the services, that speech and language services, counseling services, social work services. If they were getting research-based instruction in reading, they're still obligated to provide that. So truancy in the IDA, I just want to touch on this real quick. If a student with special education needs is truant, a school district really should be conducting a social emotional assessments and a functional behavior assessment to determine, because if the student is not coming to school because they have severe anxiety, that's not really truancy. Yes, they're not attending school, but they're not, there's a disability impeding on their ability to be able to attend school, and that needs to be addressed. So results of the assessment should be utilized to develop an appropriate positive behavior support plan to address the truant behavior. I did talk a little bit about this before. I thought I was jumping ahead, but Section 504, that's going to include a broader definition of an individual with disability. So it's any person who has a physical or mental impairment which substantially limits one or more of such person's major life activities. Learning would be a major life activity. If that they have to have a record of such impairment and is regarded as having such an impairment. So Section 504 will be broader in the sense that more people will fall under it. However, again, I talked about how you're just entitled to accommodations, not specially designed instruction. You're not entitled, you won't have in a Section 504 plan, there won't typically be goals to progress monitor. There will just be a list of accommodations, preferential seating, notes provided, extra time on tests. You often see Section 504 plans for allergies, for example. So if a student has a milk allergy or a peanut allergy, there's accommodations to make sure that that student is safe in school. And a Section 504 would require a service plan. Remedies under the IDEA. So what can happen? What can a parent seek for their child if a school district does not provide or does not do what they're supposed to under the Individuals with Disabilities Education Act? You can seek an appropriate program of placement. So if you believe let's even go back further. You can seek an initial evaluation if the child's being denied an initial evaluation. You can seek an independent educational evaluation. You can seek an appropriate program and placement for your child, reimbursement for tuition and related costs for private placement, any reimbursement for out-of-pocket costs if you've had to get tutoring, occupational therapy, speech and language therapy. And then finally, what's called compensatory education. And that is if a school district has failed to provide a student with a free appropriate public education, we can't go back in time and make them do it over again. So for those past failures, what we can obtain is what's called compensatory education. And that would be if a hearing officer were to find that, yes, student was denied their right to a free appropriate public education, and let's say it was for the past year, they can order hours of educational services so that let's say, for example, they order 500 hours. You could then go out and get 500 hours of direct instruction in academics, speech and language services, social skills instruction. So there's, services to make up for those past failures. And then finally, I added this slide because I know that I've been getting a lot of questions about, and I think a lot of fears and concerns about, the impact of recent changes, talk of the dismantling of the Department of Education, cuts to Medicaid. I want to just go through what that means and what that may potentially look like. So first off, because I do see some people when I'm having some questions, oh, does that mean my child could lose their IEP? No, your child will not lose their IEP or Section 504 plan. There are federal laws regarding these. So the Individuals with Disabilities Education Act, Section 504, the Rehabilitation Act, those are what provide for an IEP and a Section 504 plan. That is not something that the Department of Education has control over. It falls under Congress has control. Congress wrote the Individuals with Disabilities Education Act. So that is not something that can just be removed. What does the United States Department of Education do? And what are the things that we're talking about? So I think one of the major concerns that people are talking about is that under the Department of Education, there is what's called the Office for Civil Rights. And that is OCR. It's responsible for investigating student discrimination claims. So let's say you believe your child is being discriminated against. There's the notion that federal government involvement may provide a more unbiased investigation. That's how those claims would essentially be made through the Office for Civil Rights under the United States Department of Education. So if your child, let's say they were discriminated against sexually or racially or because of their disability, to file those types of claims, you would typically do that with the Office for Civil Rights under the United States Department of Education. The United States Department of Education also measures academic performance to ensure schools are providing appropriate education, resulting in successful academic performance. And then the United States Department of Education does provide for low-income students with disabilities. So those are the ways that it could potentially impact what we all are concerned about in terms of special educations and students with disabilities. And then finally, just thank you to everyone for attending. And here are a list of our offices and contact information. I do believe that there are some questions that I will answer as well. So let's see here. We have, do you need to get outside testing before going to your school for an IEP if the school is a private school? No, you do not. So Child Find, I don't know if you remember when I went over Child Find, that applies to students who are also in private schools as well. So if your child is in a private school and you want them to be evaluated for special education, you just want to reach out to your school district and say that you believe your child has special education needs and you're exploring and what could be provided by the school district. So a school district is going to offer a program within their school, unless they think that they can't meet their needs, and then they may say, okay, well, your child's appropriately placed in a private school. But when you ask them, you should again do it in writing, and you should ask for a special education evaluation because your child, you believe, has these needs. Note what the needs are, and that you're exploring the options that would be available through your local public school district. Let me know if I didn't answer that. Next question. Can teachers not tell parents child may need an IEP or have a disability or even struggling if a prior parent sued the school for saying their child needed an IEP? Okay, so if a parent had previously sued a school saying their child needed an IEP, can a teacher not tell a parent that their child may need an IEP? So I'm assuming that the parent who previously sued lost. But uh, regardless, no, a teacher should, if a child has needs, because maybe in the past the child didn't have needs, but now they do. So if a school district staff believes that a child is suspected to have a disability, remember, suspected, then they need to refer that child for an evaluation. So again, it should not matter what happened in the past. It shouldn't have anything to do with the parent who had previously sued. If again, a school district has the obligation to evaluate any students who are suspected of having a disability in any area of need. Next question. If there's a private school and they recommend an evaluation, do you have to pay for the evaluation for the school to bring someone in? This happened to me when I was a kid and I ended up not needing anything at all, but my parents had to pay for it. So if a private school is recommending an evaluation, I mean, there's no obligation to follow that recommendation. So if they brought someone in and they had that, they really shouldn't have had your parents pay for that. But there's no private schools are not, because they do not receive any federal funding, they are not obligated to implement the Individuals with Disabilities Education Act. They do not have to provide IEPs. So it's only public schools and charter schools, public school districts and charter schools. So the schools that receive federal funding are obligated to provide the services under the Individuals with Disabilities Education Act. So private schools are not obligated to provide that. They're not obligated to evaluate. So I hope that answers your question. Next question, if my school is not agreeing to my child's anxiety, do I need to request an FBA? So an FBA has to do with functional behavior assessment. I do worry a little bit about anxiety because while anxiety may impact behaviors, it's not that's more of a function of the behavior, and I don't know that addressing that through a positive behavior support plan, hey, if that works, great, but I would want to make sure that anxiety is assessed and that we're providing the coping skills instruction that the student needs to address the anxiety and any accommodations that are necessary as well. So I think I have all of the questions answered. If there's any more, please let me know. And again, certainly, please feel free to reach out to me with any questions or concerns. We do free consultations. We almost very frequently, especially in Northeastern PA, almost always take cases at no cost to parents. I'm very happy to do any other presentations. If anyone is interested in anything like that, we do them for free. If there's a particular area of topic area that you'd like me to discuss, we have a variety, and I can even develop a presentation targeting the topic area that you'd like. So again, please feel free to reach out to me. I did put my information in the chat, my email, phone number, our website. And again, thank you so much to Abilities 21 Special Needs Support Group of NEPA. I strongly encourage you to join that group on Facebook, as you will see that there's a whole lot of great information that's posted regularly. So thank you everyone for attending. Oh, it looks like one more question came in. Okay, if your child has a 504 for anxiety and ADHD and needs counseling to help cope with anxiety, the school says there's a waiting list for counseling. Is that appropriate? No, absolutely not. And it sounds like that if your child needs counseling to help with coping with anxiety, they need direct instruction. That's specially designed instruction. So your child likely needs an IEP and not just a 504 plan. So feel free to reach out to me. I'm happy to help. So if there's not any other questions, I hope everyone has a wonderful evening. Thank you all so much for joining.